Thank you very much. Distinguished conference, dear colleagues, as you have heard, my topic is about migration, and as we all know, migration is a characteristic of humankind, whether it is forced or arbitrary, but what varies, in fact, from era to era is the attitude to migration. This attitude, like how communities and ultimately the state relate to other people and ethnic groups arriving on its territory, has traditionally been left the sovereign decision of states, and thus the resulting discretionary power has been quite wide. Who to let enter, who to let resettle, and how, who to consider desirable to become part of society and who is not. For there are countless historical examples of the exclusion of groups considered to be alien. This discretion has made the state much more of a shaper of the processes affecting its population, as it can choose to be in favor of immigration or against it by controlling it. Some of these features still exist today, as in principle both EU law and the European Convention on Human Rights recognize the sovereign right of states to control entry and residence on their territory. At the same time, however, national specificities in relation to immigration are becoming increasingly unraveled, and more barriers are emerging which limit the scope for state action and which constitute a certain degree of inertia, either against the will of the state or in excess of it. These include the obligation to apply the principle of non-refoulement, the impact of compelling circumstances such as labor shortages or illegal border crossing or residence, which in many cases lead to ex post legalization of status. In the cases of humanitarian obligations, the granting of asylum has been taken out of the realm of more or less absolute state discretion and assumed by states as an international legal obligation through which the granting of asylum has become a legally binding decision-making processes. In the 20th century, we have seen examples of two major regimes in the Western world in terms of their attitude to immigration. Prior to the Second World War, there were many examples of migration being tightly controlled and humanitarian considerations being taken poorly into account. In contrast, after the Second World War, and particularly from the 1960s onwards, there was a growing emphasis on drawing lessons from the experience of the war. For example, the Geneva Refugee Convention, as was mentioned before, and the growing influence of social movements, including anti-colonialism, new left, ethnic, and racial identity, and feminism. Partly as a result of these phenomena, a revolution of minority rights emerged. In the Euro-Atlantic era, the prohibition of discrimination became a practically universal human right, which then permitted the approach to migration too. This era also saw the creation of the European Court of Human Rights, whose work has helped to transform migration issues into a legal issue and an increasingly universal one at that. Both universality and the treatment of migration within a purely legal framework created tensions. A review of the rather extensive jurisprudence of the European Court of Human Rights shows that in many areas, states struggle to find a balance between their own interest and the consideration of legal and humanitarian aspects. Under the European Convention of Human Rights, as a general rule, states have the right to control entry, residence, and expulsion of non-nationals. However, there are a number of issues that could be covered by the European Convention. In this context, these include travel bans, checks at border crossing points, transit zones, access to asylum, family life, family reunification, removal, expulsion, extradition, pushbacks, immigration detention, and the procedural guarantees that embrace all of these questions. Some of these issues are relatively long-standing. recurring problems, and some have been brought to the fore by the various migration crises of the recent years, which is not to say that these are entirely new tactics, such as transit zones or more broadly forms of territorial excision or pushback solutions. What are the forms of territorial excision to start this question? The first is the operational of extraterritorial bases. In this case, the territories are clearly under the power of the state, but the state has reservations about its own jurisdiction and responsibility over these areas. The second form is the redefining national territories status according to state desires regarding immigration, refugee flows. One more method is to have a domestic space. An internal excision of very specific areas can occur so as to avoid full state obligations regarding the treatment of unauthorized foreigners. The goal is to help manage the flow of refugees and illegal migrants. And what we can see in Europe are cases when states have declared parts of their airports or harbors, in some cases even certain international railway stations to be transit zones, international space where officials are not obliged to provide foreign nationals with some or all of the protection available to those officially on state territory. In Amour versus France case, a case from 1996, the European Court of Human Rights ruled on one hand side that, this is quotation, holding aliens in the international zone does indeed involve a restriction upon liberty, but one which is not in every respect comparable to what which obtains in centers for the detention of aliens pending deportation. Such confinement, accompanied by suitable safeguards for the persons concerned, is acceptable only in order to enable states to prevent unlawful immigration while complying with their international obligations. States' legitimate concern to foil the increasingly frequent attempts to circumvent immigration restrictions must not deprive asylum seekers of the protection afforded by the conventions. Such holding should not be prolonged excessively, otherwise there would be a risk of it turning a mere restriction of liberty into a deprivation of liberty. On the other hand side, the court also ruled about the reasoning of the French government about the zone being partially open, in the sense of the zone being open to the outside and closed on the French side. And the court noted that the mere fact that it is possible for asylum seekers to leave voluntarily the country where they wish to take refuge cannot exclude a restriction on liberty. The right to leave any country, including one's own, being guaranteed, moreover, by Protocol number 4 to the Convention. Furthermore, this possibility becomes theoretical if no other country offering protection comparable to the protection they expect to find in the country where they are seeking asylum is inclined or prepared to take them in. It can therefore be seen that the European Court of Human Rights had clearly long laid the foundations that the use of transit zones is not a way of circumventing immigration requirements. Following the case law, the court, in determining the distinction between restriction on liberty of movement and deprivation of liberty in the context of confinement of foreigners in transit zones and reception centers for the identification and registration of migrants, the factors taken into account are false. There are 4 factors, actually. The first one is the applicant's individual situation and their choices. The second one, the applicable legal regime of the respective country and its purpose. Third, the relevant duration, especially in the light of the purpose and the procedural protection enjoyed by applicants pending the events, and nature and degree of the actual restrictions imposed on or experienced by the applicants. This means that states have the right to control the entry of foreigners into their territory, and this necessarily implies that there are some admission authority procedures, authorization procedures. Therefore, absent other significant factors, the situation of an individual applying for entry and waiting for a relatively short period of time for the verification of his or her right to enter cannot be described as a deprivation of liberty imputable to the state, since in such cases the state authorities have undertaken vis-à-vis the individual no other steps than reacting to his or her wish to enter by carrying out the necessary verifications. In principle, as long as the applicant's stay in the transit zone does not exceed significantly the time needed for the examination they request, and there are no exceptional circumstances, the duration itself should not affect the court's analysis on the applicability of Article 5 in the decisive manner. That is particularly so where the individuals, while waiting for the processing of their asylum claims, benefited from procedural rights and safeguards against excessive waiting periods. Regarding the duration, we can conclude that a few weeks of restriction does not fall under Article 5, but 4 months of staying in transit zone together with unclear domestic legal regulations regarding the basis and the maximum duration of detention already violates Article 5 of the conventions. These both came from Hungarian cases, actually. Another question of the access to territory are the so-called pushback cases. Access to territory may be by air, land, or sea, but through pushbacks at sea, persons are forced back to their third country from where they have departed. The court has held on several occasions that individuals may fall within a jurisdiction when a state exercises control over them, even on the high seas. This even more applies when this happens on land, naturally. In Hirsi Gemma and others versus Italy case, the applicants were part of a group of about 200 migrants who had been intercepted by the Italian coast guards on the high seas. And they were returned to Libya under an agreement concluded between Italy and Libya, and they were not given the opportunity to ask for asylum, to apply for asylum. The court noted that the situation in Libya was well known and easy to verify on the basis of multiple sources. It therefore considered that the Italian authorities know or should have known that the applicants, when returned to Libya as irregular migrants, would be exposed to treatment in breach of the European Convention of Human Rights, and that they would not be given any kind of protection. The authorities also should have known that there were insufficient guarantees protecting asylum seekers, the applicants, from the risk of being arbitrarily returned to their countries of origin. In this case, this means to Eritrea and Somalia, and that they should have had particular regard to the lack of any asylum procedure in Libya. The fact that the applicants had failed to ask for asylum, or at least describe the risks they faced as a result of the lack of an asylum system in Libya, did not exempt Italy from complying with its obligations under Article 3 of the Convention. Thus, the destination states cannot absolve themselves from legal responsibility under norms prohibiting refoulement and norms protecting human rights. In summary, where the applicants who had presented themselves at the border seeking to lodge an asylum application and or communicating fear for their safety were removed in a summary manner to the third country from which they had sought to enter the respondent state's territory, the court applied the principles which it had set out in another Hungarian case, the Nielsen and Ahmed versus Hungary case. The court found violations of Article 3 of the Convention in these cases, among cases from Poland, Lithuania, Italy, and Greece too. Following this logic, where applicants can arguably claim that there is no guarantee that their asylum applications would be seriously examined by the authorities in the neighboring third country, and that their return to their country of origin could violate Article 3 of the Convention, the respondent state is obliged to allow the applicants to remain within its jurisdiction until such time that their claims have been properly reviewed by the competent domestic authority, and cannot deny access to its territory to persons presenting themselves at the border checkpoints who allege that they may be subjected to ill treatment if they remain on the territory of the neighboring state, unless adequate measures are taken to eliminate such risk, as it was stated in the MK and others versus Poland case. In cases of summary returns, the court set out a two-tier test to determine compliance with Article 4 of Protocol number 4 in cases where individuals cross a land border in an authorized manner, unauthorized manner, and are expelled summarily. Firstly, it has taken into account whether the state provided genuine and effective access to means of legal entry, in particular border procedures, to allow all persons who face persecution to submit an application for protection based in particular on Article 3 under conditions which ensure that the application is processed in a manner consistent with international norms, including the Convention. Secondly, where the state provided such access but an applicant did not make use of it, it has to be considered whether there were cogent reasons for not doing so, which were based on objective facts for which the state was responsible. The absence of such cogent reasons could lead to this being regarded as the consequence of the applicant's own conduct, justifying the lack of individual identification. This logic applies not only to the return of persons at the border, but also, and to a greater extent, to the return of persons residing on the territory of the state. For example, the indirect removal to an intermediary country, even if it's a contracting state, does not affect the responsibility the state to ensure that the applicant is not, as a result of its decision to expel, exposed to treatment contrary to Article 3, as it was mentioned in the TI versus UK case from 2000. The Human Rights Court is criticized from two sides for its migration practices. One is that it is not consistent enough and does not offer sufficient protection to migrants who would otherwise be vulnerable. The other criticism is that it makes it impossible to combat illegal migration. Don't stop me now. States are introducing newer and newer solutions to keep migration under control, even in the face of the court's decisions. One specific example for this is the new immigration law of the UK. During the codification period of this law, ideas were raised that British courts could be given powers to ignore European human rights decisions, rulings, and there was also a proposal to allow legal challenges to deportations to be lodged once the migrant has been removed from the UK, so they could ask for a remedy from outside, only from outside of the UK. In fact, this also shows the growing tension in the situation, and to be honest, we cannot see the solution in the near future either. Thank you very much.